Hello, everyone. This is Layla from Basics Legal, and today we will talk about something different. Have you ever heard the expression to think like a lawyer? I'm sure you've noticed that almost every lawyer has the same or similar thinking pattern. If so, you're not wrong. The reason lawyers think like they do is not due to the concepts they learn in law school. It's not due to it's not because they have read too many cases or have extensive knowledge in the field they're specializing in. It is, though, due to a specific way of approaching problems they adopt from the first year at university. The information taught can be researched and read and basically can be accessed by many. But the thinking skills are due to constant exposure to certain types of training that they go throughout law school. In mostly English-speaking countries like the UK, there's a writing system called the IRAC. The abbreviation here stands for issue, rule, application, or in some countries like the US, they call it analysis and conclusion. Lawyers are trained to spot the issues presented to them almost in a heartbeat. And they're expected to provide solutions to a problem in a timely manner. The IRAC system, though, it helps young students' brains get used to thinking like this with every case they work on. Instructors, the teachers, the professors, they will also mark the essays based on this legal analysis. Let's go through them one by one. Issue is the stage where the correct issue is spotted when hearing a problem, either directly from a client or when reading a case. It is not the same as repeating the facts of a case, but identifying the legal question there. For example, a plaintiff, someone who complains about an issue, the plaintiff comes to you and says, the medicine prescribed to me caused me irreversible damage or side effects, and the doctor did not even check my illness properly before prescribing these medicine. These are what the lawyers hear, but the things, the legal terms they write down in their notes is like this: possible torts, possible breach of duty here, professional negligence, malpractice. To summarize the facts of a case, basically, facts of a case will help them establish the legal background, but then it is up to them to establish the legal question. Once this is settled, we move on to the next, which is rule. Rule is the stage where a lawyer is expected to find the correct set of laws and rules. The rules that govern the areas to which these issues belong to. This could be directly quoting a statute or a constitution in some countries, or it could be legal principles that are expressed in your own words. Let's follow on from the previous example. If you believe there is a clear case of professional negligence or malpractice, you can refer to a relevant tort law or case law that deals with both professional negligence and malpractice, and etc. If you're from a civil law system, civil law country, you will most likely quote a legal code or a piece from constitution where the law provides elements for each part of this wrongdoing. Then we move on to application. Application is the core part of this analysis. It is where the relevant laws and principles that we talked about earlier are applied to the issues. Here, you tell the plaintiff how the laws will help them in their case and what will be expected from not just the plaintiff, but the other party as well. Here, you basically match every aspect of the case with the elements of applicable legal principles and rules. You provide possible remedies in this stage and defenses that may come from the other party. And often during this stage, it becomes clear whether there is an actual case to be brought or not. As I demonstrated here, you basically tailor the laws to the problem instead of just repeating them. Conclusion is when the lawyer is able to suggest what to do next and summarize what it all means, really. Once the lengthy analysis of the case is over, it can give definite and concise advice to the plaintiff that will lift the fog for them, if you know what I mean. The conclusion usually should not be vague, or the plaintiff shouldn't end up being confused after all. And so therefore, I would say constructing an effective and definitive conclusion is crucial to delivering the whole analysis in a way that the person in front of you will understand. We as lawyers train for years for us to be able to deliver things in a simple way to the person in front of us. This is true when writing an exam as well. A marker will make sure you sum it all up nicely and neatly. If you have paid attention, my bad, I've used the words exam and client interchangeably throughout the slide and throughout the presentation. It is because the way lawyers are trained becomes the way their brains work while practicing. In every problem they approach, be it in their field or not, like in their personal lives, relations, they adopt this type of objective thinking. They're often able to eliminate unnecessary parts of facts, which allows them to focus on problem solving more efficiently, which we'll have a look at later when I'm talking about cases. The IRAC system, the IRAC method, is very useful in approaching the problem as we've just seen. However, one of the criticisms of this approach is that it may oversimplify complex cases. This, though, may not happen as often as it is argued by some. IRAC system is still largely used and is still practical in many ways. I mentioned the word objective in the last slide. In my personal opinion, IRAC method will kind of force someone to adopt more objective approach to problems. Therefore, I believe there is yet to be a new system where IRAC falls short compared to that. I want to give you an example, and we'll go through that. We'll go through solving that problem as a lawyer using the IRAC method. And then I will give you a problem question where you can provide your own answers using IRAC method, and you'll write that down in the comment section down below. Let's look at this example question first, so you'll have an idea of how we apply this method. As you can see, I'm going to read from the slide here as well. Elsa is a regular customer at a shop in her neighborhood. She also enjoys taking walks in and around the area. One rainy day, she visits the shop to buy some items. As she enters the shop, she slips on slippery tiles and falls. She breaks her ankle, and she spends 3 days at the hospital. The shop owners apologize for what happened and just move on. To make things better, they even offer her some items for free. Elsa says there was no sign on the floor that indicated beware of the slippery floors. She wants the shop owners to pay for her hospital bills and cover her medical expenses. Let's start going through that one by one. This is what you were presented with, the facts. And let's see what the legal question here is. Issue is there's a level of duty of care, negligence, and physical harm as a result of this negligence, and possible vicarious liability. Vicarious liability is basically whether employer is also liable, or it's just their employee's fault what happened to the plaintiff. So these are issues that we will spot along the way. If you've paid attention, not every part, every sentence of these facts is taken into consideration. And I will show you why as we go along. And then we come to a rule. If it's in common law country, like the UK, tort laws will apply, as well as the case law, as well as and the statutes. Case law will determine how much it gets in terms of remedies and compensation, because there are case laws, precedents, it's precedent basically, and that will determine, and we will look at similar cases in the past, and then these similar cases will tell us what will be the compensation and how the case will go basically. And then we will move on to application. As we said, this is a lengthy part. This is where most of this analysis happens. Tort laws establish a duty of care owned by the shop to the customers, including Elsa. In this case, by not putting up the necessary cautionary signs, they're liable. Case law will determine whether the shop owners are vicariously liable or whether it was purely the employee's fault. Elsa is also expected to produce the necessary documents proving hospital expenses without being disproportionate. So you see where this comes, the picture becomes clear and the legal picture becomes clear while we're doing the analysis. And in the conclusion, we'll go on to more detail. To summarize it all. Because the shop owners apologized and offered her free items, Elsa may wish to move on and settle via mediation. It's a form of alternative dispute resolution. But at the same time, she may also wish the shop owners would pay for her hospital expenses. All these options are within her own rights. The shop owners may accept both of these choices or may offer their own arguments. They may argue in their defense that she's regular in the area and she would have been aware of the slippery state of the grounds, especially if she's a regular customer. As weak as this argument sounds, it may be one of the defenses argued by the shop owners. So you see how we picked every bit of this, these facts provided to us, and then we've applied them along with our IRAC system. And I hope you see how lawyers approach these fact findings. We don't go too much into details of she enjoys having walks around the area. So there are lots of unnecessary things that may be suggested to us during the fact finding, but it's up to us to pick important bits for us to create and establish a legal question to establish a case. This problem question is for you. You can screenshot this. It's going to be 2 pages because I couldn't fit everything in one slide. And then you can read it, and you don't need extensive legal knowledge as long as, if you'll get extra point for that. If you do, it's amazing to go through legal laws basically and to pick the important bits to apply to the case. But if you just use IRAC system solely, if you just solely apply the principles and apply the strategies, you'll be fine. And you saw what I did in the previous example. I did not use any specific laws. I did not quote from any specific constitution or country. I did not mention any legal system. All I did was I applied legal principles there. So with this one, I'm going to read it out loud, but you can screenshot it and then you you solve this problem, and then you can write your answers in the comment section below. Tom is a plumber. He likes to work mostly in the neighborhood. He knows almost everyone around him. He was contracted by Paul to fix an issue in his bedroom sink. He agreed to a return of £40. I use British pounds, excluding the parts that may needed to replace them. After working on the sink for a couple of hours, he finds that the work is more complex and that the whole sink has to be replaced. He calculates the new price, and now it is £85 for the service plus £150 for the new sink and the parts. By the way, I'm not an expert in plumbing, so my prices here may be off the charts. Paul is not happy, obviously, with the new prices and wants someone else to complete the work, and demands that Tom return the £40 he was paid for his services. Tom argues that he did the work as he was expected, as he was requested, a remuneration for the work that he did for those days. Tom also argues that Paul did not inform him prior that the sink had been inspected previously and was reported as unfixable. So you see the problem question here in terms of the plot is completely different to the previous one, but you may now start to see how we can approach this with IRAC method. And then again, you can screenshot this, both of these. I'm going to go back one more time for you to screenshot. And then we can go back here. And then when you read that, and hopefully, and I'm going to be waiting for your answers in the comment section. And thank you for watching. And subscribe to our channel, Basics Legal, and you will see my previous videos about defamation, contract law, and incorporation of legal knowledge in education system. And if you'd like to see more videos, you can stay tuned. Bye-bye.